Good morning, everyone. We will be discussing Chapter 2, Nature and Effects of Obligations. So you have to remember that doon muna tayo sa kinds of prestation. Sabi nga natin, an obligation is a juridical necessity to give, to do, or not to do. So punta muna natin yung obligation to give. So obligation to give, pwedeng dalawa yan. To give a specific thing or to give a generic thing. So doon tayo sa specific thing. Kapag sinabi natin yung duty to give, dalawa rin yan. It's either duty on the part of the obligor or duty on the part of the obligee. So doon muna tayo sa obligation to give a specific thing on the part of the obligor. Okay, naintindihan natin. So first obligation is to deliver the thing itself. So punta natin yung Article 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obligee's will. So remember Article 1244. Another duty is to preserve the thing. Puntahan na naman natin yung Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. So as a general rule, class, diligence of a good father of a family, yun ang general rule na standard of care. However, the law or the stipulation of the parties may require another standard of care. For example, sa common carriers, extraordinary diligence ang required. Another duty of the obligor in obligations to give a specific thing is to deliver the accessions and accessories. Nasa Article 1166 naman yan. Ano sinasabi ng Article 1166? The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. Let's define accessions. Accessions, everything which is produced by a thing or which is incorporated or attached thereto, either naturally or artificially. Those which cannot be removed on the thing, or if removed would cause damage to the principal. It refers to the accession continua, including accession natural. Accessories naman, class, things joined to or included with the principal thing for the latter's embellishment, better use, or completion. You have to remember, class, the parties may agree to exclude any accession or accessory of the thing. Depende yan sa pag-uusapan ng parties. Another duty of the obligor in obligation to give a specific thing is to deliver the fruits. Nasa Article 1164 naman yan. Article 1164, the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Medyo complicated tong ano na to. Provision na to. Isa-isahin natin para mas maintindihan natin, ha? Doon muna tayo sa ano, the creditor is entitled to the fruits from the time the obligation to deliver arises. Kailangan muna, class, malaman natin when obligation to deliver arises. Depende yan, class, kung ano klaseng obligation. For example, if the obligation is subject to a suspensive condition, the obligation to deliver arises from the moment the condition happens. Pag-aaralan natin sa susunod yung condition, ha? Yung obligations with condition. Obligations subject to a suspensive period The obligation to deliver arises from the moment the period expires. Kapag walang period or condition, the obligation to deliver arises upon the perfection of contract. Paano naman yung obligations arising from sources other than contracts? For example, law, quasi-delict, quasi-contract, delict. Specific provisions of law applies. So alam na natin yung yung obligation to deliver arises, from the time the obligation to deliver arises. Punta naman tayo sa fruits. Ano ang kinds of fruits? May tatlo yan. Natural, industrial, and civil. Natural, products of soil and young of animals. Industrial, produced by lands through labor. And civil, those derived by virtue of juridical relation. For example, rents. So alam na natin yung fruits. Doon naman tayo sa real versus personal right. Pag sinabi natin real right, class, it is power belonging to a person over a specific thing without a passive subject, individually determined against whom such right may be personally exercised. Meaning, class, real right, you can exercise such right against the whole world. Hindi lang sa particular na tao. Ayan ang sinasabi, without a passive subject, individually determined. How about personal right? It is a power belonging to one person to demand of another as a definite passive subject the fulfillment of a prestation to give, to do, or not to do. For example, may utang si A kay B. So kay B lang niya po pwedeng singilin. Diba? So ano yun determined yung passive subject. So alam na natin, real versus personal right. Bigyan ko kayo ng example. On March 1, 2010, A buys for example, a mango orchard from X to be delivered on April 1, 2010. Tandaan nyo March 1, binili ni A yung mango orchard kay X at i-deliver niya April 1, 2010 after 1 month. On April 1, 2010, si A, magkakaroon na siya ng right sa fruits ng mango orchard. Kasi nga, ayun yung obligation to deliver Diba? May period, diba? Halimbawa, yung property ay dineliver lang nung May 1, 2010. So may delay ng 1 month. Si A, may right siya na mag-demand sa fruits mula nung April 1, 2010. Bakit? Kasi April 1, 2010, yung usapan na i-deliver sa kanya yung mango orchard. Diba? Hindi po pwede na tanggihan ni X yung pagdedemand ni yung pagdedemand ni A kasi nga ang usapan is April 1, 2010 pero dineliver niya May 1, 2010. Halimbawa, ito ngayon ang problema, class. Paano kung si X binenta niya yung fruits? Binenta niya yung fruits nung April 20, 2010. Tandaan nyo ha. March 1, nagbentahan. April 1, ayun ang usapan na delivery. May 1, doon lang deliver the X. Okay? 3 dates. Lagyan natin ang pang-4 na date. Noong April 20, 2010, ibinenta ni X yung fruits kay B. Hindi kasama sa sale, ha? Sa contract of sale. At si B, hindi niya alam na may usapan na pala si A and X. So, nung binenta ni X yung mga mangga noong April 20, 2010 kay B at kinuha agad ni B yun, si B ay may better right over the said fruits. Bakit? Kasi sa kanya dineliver. Tandaan na, April 20 dineliver sa kanya yung fruits. May 1 lang dineliver kay A yung manggahan. So bakit si B yung may better right? Because A has no real right over the fruits. Nag-gets nyo, class? Walang real right si A over the fruits. Si B ang nagkaroon ng real right over the fruits. Bakit? Kasi sa kanya dineliver. Ano kayo ng remedy ni A? Ang remedy ni A ay habulin. Habulin for damages si X in connection with the fruits. Gets your class? Okay, halimbawa naman, nauna yung delivery kay A, tapos, binenta after the delivery kay A, binenta naman ni B, binenta naman ni X kay B yung fruits. Sino ngayon ang may better right? Si A. Kasi nauna sa kanya yung delivery. Kapag nauna sa kanya yung delivery, therefore, may better right siya. Magkakaroon siya ng real right over the fruits. So ano pwedeng gawin ni A? Kunyari na-deliver na sa kanya tapos binenta bigla ni X kay B yung fruits. Pwede niyang i-recover yung fruits kay B. Kasi nga, siya yung may real right over the fruits. Bakit siya may real right? Kasi nasa kanya yung delivery. You should always remember that it is by delivery which transfers ownership. Okay? So kung kanino unang dineliver, yun ang may real right. Tandaan nyo to non-nudis pactis, sed traditione dominia rerum transferentur. The ownership of things is transferred not by mere agreements but by delivery. It is by delivery. It is by tradition which transfers ownership, not by mere agreements. Okay? So let's now move to obligation of the obligor to deliver to give a generic thing. Ano na tatandaan nyo dyan? Article 1246. When the obligation consists in the delivery of an indeterminate or generic thing whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. So kung ang usapan ay delivery of an indeterminate or generic thing at hindi napag-usapan, hindi nakalagay doon kung ano yung quality and circumstances, si creditor cannot demand a thing of superior quality. Hindi naman din po pwedeng si debtor to deliver an inferior quality. So, kailangan i-determine para saan yung obligation at yung other circumstances. For example, A promised to deliver a vehicle to B. A knows that the car is to be used for a wedding. So, alam nila sa kasal. Alam ni A na sa kasal gagamitin yung sasakyan. Siyempre, kung sa kasal, hindi naman po pwede yung motor doon. Diba? Well, minsan may mga gumagamit ng motor, pero hindi, isolated cases lang yun, no? So, hindi niya po pwedeng i-compel si B to accept a motorcycle as the promised vehicle. Liwanag? Okay. Paano kunwari, nag-deliver si B ng nag-deliver si A ng motorcycle para sa kasala, si B tinanggap kasi trip niya na ang kanilang kasal pag-alis sila ng simbahan, gusto nila nakamotor sila para school. Ano ngayon? Anong mangyayari? Walang mangyayari. Okay lang 'yun. Because the benefit of this article may be waived by the creditor by accepting a thing of inferior quality and by the debtor by delivering a thing of superior quality. So walang problema doon. Kasi nga class, as long as it is not contrary to law, public order, public policy, morals, good customs, walang problema. Sa gusto ni B na motor na gamitin nila sa sasakyan sa kasal nila eh. Wala tayong magagawa doon. Okay? Another obligation is obligation to do, obligations not to do. Napakadali lang naman yan, di ba? Obligation to do, gawin kung ano ang napagkasunduan. However, class, ano ang limitation dyan? Involuntary servitude. Hindi mo pwedeng puwersahin yung isang tao na gawin yung isang bagay na labag sa kanyang kalooban. Obligation not to do. Ano naman to? Napakadali naman nito, class. Huwag mong gawin yung sinasabing huwag gawin. Diba? So, napakadali niyang obligation not to do. Punta naman natin, class, yung breach of obligation. Okay. O, doon na, substantial breach muna tayo. Substantial breach, class, so fundamental as to defeat the object of the parties in making the agreement. If there is substantial breach, the contract can be rescinded. Can be rescinded. So, class, hindi lahat ng breach ay will subject the contract or an obligation for rescission. That's false. Kasi kailangan substantial breach. So, paano natin masasabi kung substantial breach? Ano yan? Depende yan sa facts and circumstances of the obligation. Paano kunyari casual or slight breach? Not so fundamental. It is a not so fundamental breach of the agreement. A contract could not be rescinded because of it. So, doon sa Song Fo versus Hawaiian Philippines, 20-day delay in payment is only a slight or casual breach. So, depende yan, class. Depende yan sa facts and circumstances of the obligation. So, ano na? Ayun yung breach. Ayun yung concept ng breach. So, tatandaan ninyo, substantial lang yung pwedeng makapagpa-rescind ng contract. Hindi po pwede yung casual or slight breach. So, ano naman yung modes of breach? Okay. Modes of breach. First mode is dolo or fraud. What is fraud? It is the deliberate and intentional evasion of the normal fulfillment of obligation. It is demandable in all obligations. Class class. Pag pinag-uusapan natin yung yung fraud as a mode of breach, we are not talking about fraud in creation of contracts. Because there are two kinds of fraud. Dolo cosante and dolo incidente. What is dolo cosante? Dolo cosante, it is a fraud in the creation of contract. In this case, the party would still the party would not have given consent had he known of the fraud. So consent of the party is vitiated. Therefore, the contract is voidable. Pag-uusapan natin yan, latter part of the SEM. Maliwanag? So, dolo cosante. Dolo cosante, hindi natin yung pinag-uusapan as a mode of breach. Ang pag-uusapan natin na dolo as a mode of breach is dolo incidente. What is dolo incidente? Dolo incidente, it is the fraud in the performance of an obligation. Tanda na, dolo incidente. Okay? Tingnan naman natin. Non-waiver. Natandaan nyo, class? A waiver of action for future fraud is void. However, a waiver of action for past fraud is valid. Bakit yung future fraud void daw? Kasi, class, parang sinabi mo na okay lang na nalukohin mo ako. Okay lang, walang problema. That's against public policy. So, kung future fraud void, bakit yung past fraud valid? Kasi, class, yung past fraud, pag winave mo yung action for past fraud, that's condonation. That's an act of forgiveness. Maliwanag? So, wala tayong magagawa kung gusto niya magpatawad eh. Ganun talaga. Diba? So, ano naman effect ng fraud as a mode of breach? Ang effect yan is damages should be paid by the guilty party. Okay? Next naman tayo. Next mode of breach, negligence. Ano naman yung concept of negligence? Negligence, napag-aralan natin ito sa quasi-delict, omission of that diligence required by the nature of the obligation corresponds to the circumstances of the person, of the time, of the place. So let's differentiate culpa, which is negligence, and dolo, which is fraud. With regard to malice, dolo or fraud, there is deliberate intention to cause injury. Pag culpa or negligence, there is no deliberate intention. Waiver for liability for future fraud is void. For negligence, waiver for liability in a sense is valid. As long as negligence is not gross to be tantamount to fraud. Anong evidence required? Fraud must be clearly proved. Negligence presumed from the breach of obligation. Mitigation, fraud cannot be mitigated by the courts kasi nga intentional siya. Negligence can be mitigated according to circumstances. Culpa contractual. Negligence in the performance of a pre-existing contractual obligation resulting in breach of obligation. It is the one referred in Article 1172. When the employer is sued jointly with a negligent employee, the employee can be held solidarily liable with the employer. So class, culpa contractual, there must be a pre-existing contract. The court has discretion to mitigate liability according to the circumstances in cases of culpa contractual. So ano yung mga circumstances? Nature of the obligation, person, time, and place. Pag-usapan natin, Gutierrez versus Gutierrez, discuss to previously. Owner of truck was held jointly and severally liable along with his driver because there was a contract between him and the driver. De Gia versus Manila Electric. Meralco cannot avail itself of the defense that it had exercised due care in the selection of its employees since there is a contractual obligation between it and the victim. Culpa Aquiliana, Pasidelic, ha? The failure to observe the care required by law with respect to other persons who are not bound by contract with the actor. Ano ang defense? An employer or master may exempt himself from liability under the last paragraph of Article 2180 of the New Civil Code by proving that he had exercised due diligence to prevent damage. Balik tayo sa standard of care para matandaan ninyo, ha? Bonus pater familias or good father of the family. If the law or contract does not state the diligence required, because good father of the family is the general rule. Okay? However, if the law or stipulation of the parties requires another standard of care, for example, extraordinary diligence for common carriers, for innkeepers, lesser than extraordinary. Sa banks, extraordinary din yan. So maraming iba pa, ha? Ano naman yung effects ng negligence? Demandable but courts may regulate according to circumstances. Punta naman natin, class, yung third breach. Third mode of breach. It is delay or mora. Ano tong delay na to? It is the failure of obligor to fulfill obligation from the time of judicial or extrajudicial demand. There can be delay only in positive obligations to do and to give and not on negative obligations. Not to do or not to give. Diba? Logical naman yan, class. Nawala si ulang delay doon. Okay. For example, class, A is obliged to deliver a car to B on March 31, 2022. Gets nyo? A is obliged to deliver a car to B on March 31, 2022. Dumating yung March 31, 2022. Ano na ba siya? Obligation to deliver na, di ba? Arises. April 2, 2022, hindi pa rin deliver. Masasabi ba natin delay na si A? The answer is no. Why? Because there's need to demand. Okay? So class, hindi ibig sabihin na may date na nakalagay, hindi na kailangan ng demand. Kailangan pa rin ng demand. Class. So para hindi kayong malito, may tinatawag minsan na default. So para hindi kayo malito, although delayed na ako, kasi nga ang usapan namin is March 31, 2022, pero hindi pa ako default. Bakit? Kasi wala pang demand. So kapag nakapag-demand na siya sa akin, yun na, magiging default na ako. Gets nyo yan, ha? Ano yung kinds of delay? Mora solvendi and mora accipiendi and compensation morei. O, puntahan muna natin yung mora solvendi. It is delay on the part of the debtor. So, delay on the part of the debtor in the fulfillment of the prestation due to causes imputable to the debtor. It may be ex re or ex persona. What do you mean by ex re? To give. Ex persona, to do. What are the requisites for moral solvency? Obligation is demandable and already liquidated. B, debtor delays performance. C, creditor requires the performance judicially or extrajudicially. Meaning class, may demand. Okay? Kasi kung walang demand, hindi siya magiging default. General rule, creditor should make a demand before debtor incurs delay. Class ha, tatandaan ninyo, demand is necessary in order for a debtor to incur delay. Although, even if a period has been fixed in the obligation. Yung example natin kanina, di ba, yung March 31, 2022. Kahit na may usapan na sila ng March 31, 2022, kung walang demand, hindi magiging delay or default si A. However, class, that's only a general rule that the demand is necessary to incur before debtor incurs delay. What are the exceptions? First is when the obligation so provides. Nasa caudal yan, class. Ano ibig sabihin nun? Kapag sinabi doon sa kontrata na hindi na kailangan ng demand. Okay? But there's no need to demand in order for the debtor to incur delay. Okay? Or to be in default. When the law so provides. That's the second exception. For example, taxes. Kailangan pa ba ng demand? Pagbabayad tayo ng taxes, di ba hindi na? Kasi nasa batas na yon. When time is of the essence. For example, wedding cake. Umorder ako ng wedding cake kasi ikakasal kami. Di ba? So, kailangan yung wedding cake? Malamang sa kasal ko, di ba? Kailangan ko pa ba ng demand na kailangan ko yun sa kasal ko? Siyempre, hindi na, di ba? Ano gagawin namin dyan sa wedding cake after ng kasal? Di ba? Ano gagawin namin merienda? So, hindi na kailangan. Time is of the essence. And the last one is when demand would be useless. For example, when the impossibility is caused by the debtor by hiding the thing itself, or when the impossibility is caused by a fortuitous event, but the debtor has bound himself liable in cases of such events. Okay? So that's the 4 exceptions. Nasa caudal yan. Even without demand, the debtor will be in default if he expressly recognizes that he has incurred in delay. That's waiver. The one in default is liable for interest upon extrajudicial demand. However, in the absence of an extrajudicial demand, the interest shall commence from the filing of the complaint because that will serve as in demand. Diba? In reciprocal obligations, there is no delay if the other party does not perform or is not ready to comply. Delay begins when one party fulfills his obligation. What do we mean by reciprocal obligations, class? Reciprocal obligations. Both parties are debtors and creditors of each other. So pareho sila may obligation. So pag hindi pa ginagawa nung isa yung obligation niya, hindi ka delay. Pero pag ginawa na nung isa, delay ka na. Walag? Ano effects ng moral solvency? For determinate objects, the delay places the risk of the thing on the debtor. So kapag nasira yan because of fortuitous event, kasalanan na ni creditor, ni debtor, ba? Ni obligor. Debtor becomes liable for damages. Ayan yung effects ng mora solvendi. Punta naman natin yung mora accipiendi. Mora accipiendi, it is the delay in the performance based on the omission by the creditor of the necessary cooperation, especially acceptance on his part. So, generally, class, the debtor can perform the prestation anytime before the maturity date. Unless expressly stipulated na pwede lang niya i-perform yung obligation on a specific date, specific period. Ano ang requisites ng mora accipiendi? 1, there is an offer of performance by the debtor who has the required capacity. Letter B, offer must be to comply with the prestation as it should be performed. Letter C, creditor refuses the performance without just cause. So si debtor, gusto lang niyang magbayad. Gusto lang niyang i-deliver yung kanyang obligation. Ayaw tanggapin ni creditor without any just cause. So, ang delay nun is on the part of the creditor. Ano ngayon ang effects ng mora accipiendi? First, responsibility of the debtor is reduced and limited to fraud and gross negligence. Bakit? Anong ibig sabihin nun? Bakit limited na sa fraud and gross negligence? Malamang hindi mo na siya po pwedeng singilin hindi mo na siya po pwedeng gawing liable for delay. Kasi ang may delay nga si creditor, di ba? Debtor is exempted from the risk of loss of the thing. So kapag kunwari nagkaroon ng fortuitous event, biglang tinamaan ng kidlat yung sasakyan, yung specific determinate na sasakyan. Tinamaan na kidlat. Sino na may risk of loss nun? Si creditor na kasi una pa lang tinanggihan na niya. Tinanggihan niya nung ibinibigay sa kanya without any just cause. Class, maliwanag dapat yan ha. Without any just cause. Para mas maliwanag, okay. Si A may obligation to deliver a specific vehicle to B on March 31, 2022. No March 31, 2022, dinala ni A yung specific vehicle kay B. Si B, ayaw niyang tanggapin without any just cause. So si A, wala siyang magawa, binalik niya sa bahay. Kinagabihan nun, tinamaan ng kidlat. Sino ngayon ang may kasalanan? Sino ngayon ang may risk of loss? Si creditor na. Kasi, ang RT niya eh. Di ba? All expenses incurred by the debtor for the preservation of the thing after the mora shall be chargeable to the creditor. So kapag may mga ginawa si debtor para ma-maintain, ma-preserve yung thing, chargeable yon kay creditor. Bakit kay creditor? Kasi siya naman yung kasi nga ayaw niyang tanggapin nung una pa lang. So, naobliga ngayon si debtor na siya na yung umayos. Fourth, if the obligation bears interest, the debtor does not have to pay the same from the moment of the creditor's delay. Okay? So, hindi na siya magbabayad ng interest from the moment of the creditor's delay. Bakit? Kasi nga kasalanan ni creditor kung bakit hindi niya na-deliver. Letter E, creditor becomes liable for damages. And letter F, debtor may relieve himself of the obligation by consignation. Ano tong consignation? Pag-aaralan natin yan before midterms. So para lang may alam tayo, consignation class, pag nag-tender of payment, meaning nag-offer ka na to pay or to deliver your the prestation to the obligee, hindi tinanggap, may remedy ka to consign the money or the prestation to the court. Ang tawag sa process na yan is consignation. O kapag compensation mori, mutual delay in reciprocal obligations. The delay of one party cancels the delay of the another. Meaning, parehong may delay. So, ano yung mga modes of breach? Fraud, negligence, delay. Fourth mode of breach is contravention of the tenor of the obligation. So, hindi mo sinunod yung provisions of the obligations. So, for example, in Chavez versus Gonzalez, it is understood from the tenor of the contract that it is aimed for the typewriter to be repaired within a reasonable amount of time. Otherwise, to have it returned to the owner in the same manner as when it was brought. Alam ko na, aside case ko yan. Telefast Communications versus Castro. There was a contravention of the tenor of the obligation when it failed to deliver the telegram to the US. So may contravention daw. Mga cases na yan. So hindi sinunod yung tenor. So class, ano ang modes of breach? Fraud, negligence, delay, and contravention of the tenor of the obligation. So tapos na tayo sa modes of breach. Doon naman tayo sa remedies of creditor in case of breach. So action for performance. First is action for specific performance in obligation to give a specific thing. So ano yung kailangan doon? Sa action for specific performance. So kailangan doon is yung the very thing itself should be delivered. Liwanag? Action for substituted performance in obligation to give a generic thing. The obligation can be performed by a third person at the expense of the debtor. Action for substituted performance or undoing of poor work in obligation to do. So, nagigets ba yung ano? So, una natin, action for specific performance in obligation to give a specific thing. Ang gagawin doon is, yung mismo pinag-usapan, yun ay i-deliver. Action for substituted performance in obligation to give a generic thing. The obligation can be performed by a third person at the expense of the debtor. Doon naman tayo sa action for substituted performance or undoing of poor work in obligation to do. The obligation can be performed by a third person at the expense of the debtor. If it is still possible, the poor work can be undone by a third person at the debtor's expense. So yung poor work, ibabalik mo tatanggalin mo yung poor work, undoing of poor work. Remember this, one cannot compel a person to do something against his will. The only remedy is that of damages. Anong legal basis niyan? The constitutional prohibition on involuntary servitude. So Chavez versus Gonzalez, sinabi natin kanina, the owner of the typewriter can have his typewriter fixed by a third person at the expense of the one who poorly worked on his typewriter. Paano naman yung sa obligation not to do? Action for undoing in obligation not to do. If it is still possible, the action can be undone by a third person at the debtor's expense. Kasi nga, ang usapan doon, wag mong gagawin. Ginawa niya. So, undoing. So, first remedy is action for performance, di ba? Yung binanggit ko kanina, specific performance, substituted performance, undoing of poor work, etc. Another remedy is action for damages. So, hingi ka ng damages. Another remedy is action for rescission. Ano yung rescission? Rescission class, mutual restitution is required to bring back the parties to their original situation prior to the inception of the contract. So, balikan. Di ba? Kung ano yung parang ibabalik nila yung status nila prior to the perfection of the contract. One has to choose either for specific performance or rescission. One cannot have both. Diba? However, class, pwede naman na una mong pinili specific performance pero dumating yung point na it is impossible for the debtor to perform the obligation. Therefore, pwede na siyang rescission. Okay, doon naman tayo sa subsidiary remedies of creditor. Subsidiary. First is action subrogatoria. What is action subrogatoria? It is the action wherein the creditor may exercise in the place of his negligent debtor in order to preserve or recover for the patrimony of the debtor the product of such action, then obtain therefrom the satisfaction of his debt. So, di ba, parang medyo complicated. Ganito. Para mas maintindihan natin, hiwa-hiwalayin natin. Elements. Ano elements sa action subrogatoria? Debtor must be insolvent. Second, malicious or negligent inaction of the debtor might endanger the claim of the creditor. Letter C, the credit of the debtor against a third person is certain, demandable, and liquidated. And fourth, the debtor's right against the third person must be susceptible of being transformed to patrimonial value for the benefit of the creditor. Meaning, class, ganito. Ganito, ha? Si A may utang kay B. Okay? May utang kay B. Hindi niya nababayaran. Insolvent siya. Wala siyang pera. O wala siyang... Ano bang technical definition ng insolvent? Mas marami yung liabilities mo kasi sa assets mo. Diba? So, si A, may utang siya kay B. Si A, insolvent. So, si B, in order to protect his interest, diba? Kailangan niyang i-identify kung saan may credit si A, si debtor, si A, sa ibang tao. Okay? For example, si A pala may mga pautang siya sa ibang tao. So para ma-secure, ma-preserve yung right ni B, yung utang ni A kay B, pwede niyang i-preserve yung utang ng ibang tao kay A. Okay? Pero class, may exceptions yan. May exceptions na kahit na may perang, for example, si A, 'di ba si A ngayon may utang. Ano siya, pangalan to, binibigyan siya ng support. For example, ni D. Kahit na technically may utang si DKA, may obligation si DKA, si B, hindi niya po pwedeng hindi niya pwedeng kumbaga, i-preserve yun, singilin yung si D para mabayaran yung utang ni A. Bakit? Kasi inherent right ni debtor yon na magkaroon ng right to existence, yung support. So ano yung mga exceptions to the rule? Yung inherent rights of debtor. Right to existence, rights or relations of a public character, rights of an honorary character, diba? Etc. So nagigets yung class, ha? Ayun yung action subrogatoria. I-hold mo yung mga i-identify mo yung mga may mga utang kay debtor mo. Para sila yung mga ay yung ibabayad nila kay debtor, pwede lang ibayad sa'yo. Ano naman yung action Pollyanna? Action Pollyanna, it is the right to revoke the acts which the debtors may have done to defraud his creditors. Subsidiary to. It is an action of last resort. Okay, for example, si A may utang kay B. Walang pambayad si A. Ang ginawa nga hindi, pero may mga properties si A. Natuklasan ni B na yung mga properties ni A ay dinonate niya kung kani-kanino. Doon sa kaibigan niyan si C, sa kumare niyang si D, etc. Diba? That's fraudulent. Why? Wala ka na pambayad, nagdo-donate ka pa, di ba? Ibig sa bayaran mo ko. So wala kang talagang balak na bayaran ako. Walang balak bayaran si B. Dinonate mo pa yung mga dapat na pwede mo namang ibenta para bayaran si B. Okay? Ano yung limitations nito, class? Kailangan mauuna yung utang ni A kay B kaysa dun sa mga donations, yung mga fraudulent conveyances. Maliwanag? So hindi magiging applicable ang aksyon Pollyanna kapag nauna yung donation bago yung utang. Ano ang requisites ng aksyon Pollyanna? As stated in Ke Hong Cheng versus CA. First, trial court judgment with a writ of execution. Letter B, the sheriff's failure to enforce the judgment. Letter C, the creditor has exhausted all of the debtor's property. Letter D, all legal remedies must be exhausted first. So, ibig sabihin, kailangan maghanap muna ng paraan bago tayo pumunta dun sa bago mo pagdiskitahan yung mga donations. Kasi malay mo, kahit na nag-donate, may pera naman pala. Diba? So, may mga specific remedies na makikita sa iba't ibang panig ng New Civil Code for the lesser versus sublessee sa Article 1652, laborers versus owner 1729, vendi a retro versus vendi a retros transferee, Article 1608, and principal versus substitution appropriated by agent, Article 1893. Okay. So ito na. Ito na yung ano natin. Ito yung isa laging lumalabas sa exam. Bar exam, etc. Extinguishment of liability in case of breach due to fortuitous event. What is a fortuitous event? It is any event which cannot be foreseen or which is inevitable. So pwede siyang act of God or act of man. So ang pag-acts of God, events are totally independent of human will. For example, earthquake, flood, lightning. Acts of man, an event independent of the will of the debtor but not of other human wills. So, ang kailangan dyan, class, sa fortuitous event, kasi class, for example, war, robbery, that's an act of man. Those are acts of man. Diba? Pero, pwede siya maging fortuitous event. Bakit? Kailangan lang, class, na it must be independent of the will of the debtor. Kahit na hindi siya independent sa will ng other human beings, ang pinakamalaga doon is it must be independent of the will of the debtor. Okay, so doon sa isang Supreme Court decision, Austria versus CA, the girl who was robbed should not be liable as during that time, the level of criminality was not yet high. Thus, there was no negligence on her part. Ano ang requisites ng fortuitous event? Event unforeseeable or though foreseen is inevitable. Second, event independent of human will or at least will of debtor. Sinabi ko kanina. 3, debtor cannot perform in proper or normal manner. And 4, debtor not guilty of concurrent negligence. Okay, walang negligence on his part. The concurrent fault of a person does not exempt him from liability. Doon sa case na inassign ko isa, one Nakpil versus Sons versus CA. Nakpil and Sons cannot invoke the fortuitous event, the earthquake, as they are guilty of concurrent negligence. So, again class, general rule, fortuitous event extinguishes an obligation. Exception. If it expressly specified by law. So, example dyan, Articles 1942, 2001, 2147, 552, at marami pang iba. Stipulation of parties. Kapag nilagay sa stipulation na a fortuitous event shall not exempt the debtor from liability. Yon. Ganun ang example nun. 3, assumption of risk. For example, insurance. Okay? 4, fraud and malice. Diba? So it will not exempt you from fortuitous, the fortuitous event will not exempt you if there is fraud or malice. Debtor already in delay, sinabi ko yan kanina. Debtor guilty of concurrent negligence. And liability arising from a criminal act, except if debtor tenders thing and creditor unjustifiably refuses to receive. So those are the exceptions to the rule that a fortuitous event extinguishes an obligation. Last topic is transmissibility of rights. Ano ang general rule? All rights acquired by virtue of an obligation are transmissible. That's in Article 1178. Exceptions, prohibited by law, prohibited by stipulation of the parties, and its nature. Okay? So that's it, class, for the chapter 2, the nature and effects of obligation. Okay? Next topic is chapter 3. Thank you.